Thank you very much, Dasi, and good morning again, ladies and gentlemen. It is a true pleasure to be here today with all of you, not only, of course, to participate in the ceremonies, the important ceremonies, but also to try to give you input from our side, the side of the European Union Intellectual Property Agency, in what regards an important IP right, an important industry in Europe, which is designs. I think that it is fair to say that the case law of the Court of Justice, and of course I would like to ask you to bear with me during this presentation, since of course case law can be a quite technical element and aspect of IP rights. So of course, during the presentation, I might go into technical details, but these are necessary, I think. I think it's fair to say that the case law, in terms of designs, in the area of designs in 2016, by the Court of Justice, the General Court, was quite scarce. And therefore, I think it would also be interesting to give you a broader perspective, not only about the case law on designs, but also on the current functioning of the design system, at least the community design system, and its current challenges ahead in what regards design protection in both legislative but also jurisprudence aspects. I will briefly address in this case two preliminary ruling cases which are currently pending before the Court of Justice. Here the idea is not to take position on these cases, obviously, which are not closed, but to explain the progress which we might expect this year in terms of the interpretation of our community design regulation. In a second part, I will also give account of three recent decisions of our boards of appeal, since, of course, at the EUIPO we have a first instance that takes decisions, examine the applications, then we have the possibility of these decisions to be appealed to our boards of appeal. There is also the possibility to appeal these decisions of the boards to the General Court of the European Union. And last but not least, you can even go to a fourth instance, which is the European Court of Justice, for points of law only, with which you are not in agreement with the decision of the General Court. So I will give you account of these three recent decisions of the Boards of Appeal and Judgments of the General Court and try to explain the place that they hold in the convergence programs of the Office. Convergence programs means the work that we at the Office do with our national offices of our member states in order to converge in the way we apply the same design laws that we have in Europe, since we have a community regulation for designs that regulates and administers the community design, but we have also a directive on designs that, of course, establish the principles for the law in member states in terms of designs. Last but not least, certainly not least, I would also invite you to reflect on the possible future perspectives of the registered community design system. So starting with the state of play, in what regards the main feature of the design, the community design systems, as you might know, the community design system was created by regulation EC 6 2002, entered into force in April 2003. So almost 15 years have passed since the creation. It is a title that is administered by the EUIPO, the EU agency responsible for the administration of unitary EU rights, in this case, designs, but also trademarks. With one application, in one language, you can cover the territory of the 28, the still 28 member states of the European Union. This is also the unitary character that was also mentioned here in a previous presentation by Margot Frolinger regarding the unitary patents. The design, the community design has unitary effects in the the territory of the 28 member states. There is the possibility of filing multiple applications. There is the possibility also to defer publication, and here you can also find some resemblances with the patent system, which is of course part of this family of IP rights. And like Margot also mentioned, it is possible for the owner of the design to prohibit the production, but also the import and the sales of this product throughout the European Union. It's the issue of customs actions regarding community designs protected in the European Union. Since its creation in 2003, we have received more than 1 million designs at the office in Alicante. The system, I think, it's a clear success since it responds to user needs and as you can see it, is still growing in terms of applications. Last year, 2016, the office received for the first time more than 100,000 design applications. 100,000 design applications were received. About 95% of direct design filings are done electronically through our website using our e-filing for designs, since our location is not as central as, for instance, the location of the European Patent Organization in Munich. We are located in the south of Spain. So it's natural that the users, when they interact with us, they use our electronic tools to do it. But we also have the possibility to have a fast track for designs that reached record figures with 27% of applications submitted via fast track and an average time from application to publication of a design of less than 1 day. So if you apply for a community design, probably, if you do it through our fast track possibility, you will get your design application published in 1 day. Registrations of community designs of the office take normally 2 weeks. So after 2 weeks, you can have your design registered. Fast-tracked applications can take 24 hours. So you can also get a registration for a community design in 24 hours. I think that it's fair to say that the system is easy to use. It is affordable, since you pay 350 euros for one application of one design, and you pay 550 for 10 designs, if you want to include 10 designs in your application, and assures a swift grant of rights in this case. When we talk about the use of the design protection systems, apart from the legal perspective, which is interesting, of the IP rights, I think it is also important to understand what is the impact of the design industries to the European Union economy. What is the economic dimension of design industries in the EU? In accordance with the EUIPO and EPO study on the contribution of IP-intensive industries to the EU economy, that I mentioned also early this morning, design industries contribute to 13.4% of the total GDP creation in the European Union. So almost 14% of the total GDP creation in the European Union is directly or indirectly associated with designs. In what regards employment, designs contribute to almost 12% of the total employment creation in the European Union. As you can see also from this map, Latvia is clearly above the average in terms of the intensive use of designs when compared with the total average of use in the European Union. This means that design-intensive industries play a very important and central role in the EU economy, and that we, as public administrations, should continue to strive to enhance the design protection systems in Europe, always for the benefit of the users. But in order to do that, to reinforce the system, I believe it is also important to reinforce the predictability and the legal certainty of the system. And therefore, it is also important to understand the existing case law on designs, the case law from the European courts and from our boards of appeal. In this regard, I will briefly address these two preliminary ruling cases which are currently pending before the Court of Justice I mentioned before. And the idea, of course, is not to take position on these cases, which are not closed, but to explain the progress which we might expect this year in the interpretation of our design law. And in the second part, I will give account of three recent judgments from the Court of Justice. Let's start with the pending preliminary ruling cases before the Court of Justice. The first case that I have selected, it's case C395 Doseram versus Seram. Article 8.1 of the Community Design Regulation provides that a community design shall not subsist in features of appearance of a product which are solely dictated by its technical function. This is what is stated by Article 8.1 of our design regulation. The referring court in this case, and we're talking about the Oberlandgericht of Düsseldorf, notes that there are viable alternative shapes for the contested design. It also observes that Article 8.1 of the regulation gives rise to two radically different interpretations which can be drawn from the case law of national courts in Europe and doctrinal studies. As you know, the office is not bound by decisions of national court, but the office and the boards of appeal are obliged to know, on the first hand, and to take into consideration the decisions of the national courts in this case. And this is important for this case particular. In accordance with the first possible interpretation, Article 8.1 of the regulation is inapplicable where alternative shapes exist, irrespective of whether aesthetics considerations underline the development of the design. Recital 10 of the same regulation makes it clear that an aesthetic quality is not required. This approach finds support in the German and UK case law. Again, we are not bound by this case law, but we need to take it into consideration. And we might also agree with it by matter of fact. On a second possible interpretation, Article 8.1 of the regulation applies, where, first, each and every essential feature of the appearance of the design is dictated by a technical function, and where aesthetic considerations are entirely irrelevant. This approach finds support in our own practice and on the third Board of Appeal case law. A possible answer to this case, Article 8.1 of the regulation does not in fact require that a given feature or a combination of the different features must be the only means by which the product's technical function can be achieved. Article 8.1 of the regulation must be construed as prohibiting protection to a community design only where both its individual features of appearance and the specific configuration resulting from the combination of those individual features solely aim at allowing the product to perform a technical function, to the exclusion of any other function simultaneously performed by the product, such as ornamental, ergonomics, or similar functions. It is important to draw a dividing line between pure technical functionality and ergonomics. Ergonomics are usually understood as the study or means to minimize physical effort or discomfort and hence maximize efficiency, or in applied arts, as the parts of qualities of a product's design which make it easier to use, to put it in plain language. Ergonomics does not condition in itself the technical function performed by the product, even if it aims at optimizing a utility by making a product more pleasant to use. Such concept cannot be irreducible to a mere technical function, as its purpose is to add to or transcend this technical function by features which contribute to the appearance, to the global and outside appearance of the product. It is true that an aesthetic quality is not a protection recital, a requirement. This is foreseen in recital 10 of the regulation. But however, regard must be added to the fact that the term quality denotes a value judgment. The irrelevance of any specific aesthetic thresholds in qualitative terms neither contradicts nor undermines the rationale of design law, which is to reward an effort to enhance the appearance of a product. I think that we can all agree with this statement. And this is the raison d'être of the design protection. The importance to give to the creative effort in enhancing this appearance, not as a protection requirement, but as a relevant factor of the examination of Article 8.1 that I referred to in the beginning, it is justified if the aesthetic merit is in itself irrelevant, and an aesthetic effort can nevertheless be relevant to the extent that it may show that the features on the appearance of the product serve purposes which are not solely technical, such as ornamental, ergonomics, or any other function. The second case that I have selected is case C397 Acacia Pneugarda versus Audi, the car maker. In accordance with Article 110 of the Community Design Regulation, currently protection as a community design shall not exist for a design which constitutes a component part of a complex product used within the meaning of Article 19.1 for the purpose of the repair of that complex product so as to restore its original appearance. And here we are talking about spare parts. Recital 13 of the same regulation foresees that it is appropriate not to confer any protection as a community design for a design which is applied to or incorporated in a product which constitutes a component part of a complex product, upon whose appearance the design is dependent, and which is used for the purpose of the repair of a complex product so as to restore its original appearance. The infringement action is pending before the Corte di Appello di Milano, the appeal court in Milan, which as a preliminary opinion favors the defendant's point of view. According to the defendant, given the close aesthetic complementarity between the appearance of wheel rims and the overall appearance of the original vehicles, Audi's exclusive rights on its wheel rims cannot be enforced. This is claimed to be so because the wheel rims are component parts of a complex product used within the meaning of Article 19.1 for the purpose of the repair of that complex product so as to restore its original appearance within the meaning of Article 110 of the Community Design Regulation. Audi, on its side, considers, on the contrary, that Article 110 of the Community Design does not apply and therefore not limit the exclusive rights obtained on the community design because the wheel rims are elements which have autonomous aesthetic value and are aesthetically independent vis-à-vis the complex product. In other words, Audi claims that the shape of the wheel rims is not dependent on the shape of the complex product. This is said to be illustrated by the fact that the wheel rims at issue can be mounted on different models of vehicles. The outcome of the dispute is likely to depend largely on whether Recital 13 of the Design Regulation adds a condition to Article 110, in which case this recital should be ignored, in my view, because recitals cannot take precedence over substantive provisions, as we all know, or merely serves to interpret Article 110, which has always been referred to as the must-match exception. If a strict interpretation of this Article 110.1 prevails, Recital 13 can serve to support the view that the application of Article 110 is subject to a dependence rule. Article 110 would be restricted to component parts which are dependent on the appearance of the complex product in the sense that such parts ideally should match the overall appearance of the complex product. This should not apply to wheel rims. According to a more competition-oriented approach, followed by Commission in the observations in this case, the word dependent in Recital 13 would only require a close aesthetic complementarity between the complex product on the one hand and its component parts, such as to deter consumers from choosing a compatible substitute of a different appearance. Let's now move to the recent Board of Appeal case law and General Court decisions in the area of invalidity. Here the first case that I have selected is case T16 of 2016, Maas Jägermeister versus the EUIPO. Here the community design cannot be shown, so this is not the community design application because it's not published yet, so it's confidential yet, and the date of filing has not been granted so far. The representation of the design in this case must be treated as confidential. But the issue is, however, similar to the picture that I'm showing you, which is public and non-confidential. The community design applicant has filed a multiple application for two designs which represent a cup which is stacked on a bottle. And the product indicated in the application was beaker. That was the product that was applied for. The examiner at the office raised an objection because, as in the case of the picture on the side, it was unclear what the applicant was trying to protect. The cup alone or the cup together with the bottle. Assuming the applicant wanted to represent the bottle only for illustrating how the design is used, the examiner suggested that a visual disclaimer, such as blurring or the use of dotted lines, which is a normal and usual practice, be used in order to make clear that the bottle is not part of the scope of the protection that is being sought in this case. The examiner proposed alternatively to add bottles in the indication of the product if the applicant's intention was also to protect the bottle. The applicant said no to both suggestions and lodged an appeal against the decision of the examiner. He complained, the applicant, that a filing date had not been granted, given that, in his opinion, the only requirement for such a filing date to be granted under Article 36 of the Design Regulation and Article 4 of the Implementing Regulation is that the graphical reproduction be of a sufficient material quality. The General Court confirmed that the rules governing the representation of the design do not concern only the material quality, but also the content. A representation which leaves doubt on the subject matter of the protection, on the scope of this protection, causes legal uncertainty, and this is incompatible with the purpose of design protection. This is why, like for trademarks, the representation must be sufficient, clear, and precise on what applicants seek to protect. To conclude, I think it is also important here to remember that the EUIPO, together with its partners, national offices of member states, have recently concluded a convergence program called CP6, which precisely deals with the visual disclaimers which can be used in order to clarify that, in this case, neither the bottle nor the hand are part of the design. So since 2016, after having reached this agreement between all the offices, the national offices, and the EUIPO, there is now legal certainty, clarity in what is required in terms of graphical representation of designs. And I think this is a huge advantage and benefit for the users that now have clear guidance from our guidelines, but also from the guidelines and work instructions from the national offices, and know how they should represent graphically their design applications. The second case that I have selected is case 82814, Anthrax versus the EUIPO. And this case addresses the notion of the density of prior art. It's another concept. The two designs for the radiators that you can see there present objective similarities. But would the differences suffice to justify protecting the contested design if we show that many similar designs exist and that the state of the art is now crowded in what regards radiators? In a first judgment, the General Court had said that the density of the prior art, that is, the existence of many designs having similar characteristics coexisting on a given market, does not limit the degree of freedom of the designer, but may impact the manner in which the informed users perceive the design. The more standardized some features are, then the more important become the differences. The General Court did therefore not rule out the possibility that the contested design could have individual character and could be valid if the public was extremely attentive to details as a result of the density of the prior art. The Boards of Appeal of the Office took another decision in which it said that the high density of the prior art in a given economic sector is not a well-known fact, and therefore it must be proven by the party which relies on it. In this case, the proprietor of the design had submitted only 5 catalogues, and the Board of Appeal considered that this was insufficient to establish the existence of a family of radiators on the date on which the decision was adopted. The General Court, nevertheless, precised the Boards of Appeal on one important point. The relevant point in time when the density of the prior art must be established is not the date on which the boards look at the case and take its decision, but it is the date of the filing or the date of priority presented at the office. The General Court precises the understanding of the Board of Appeal on another point. The density of the prior art can, in some circumstances, be a well-known fact which does not need to be proven by the parties. This is clearly stated by the court. If I say that there exists many variations for men's jackets, but that they all have a pocket on the left-hand side of the chest, this is well-known fact taken from everyday experience. As a result, the fact that two men jackets have the same characteristics is of less relevance. If I say that everyone knows that wall convectors have such characteristics, it might not be a well-known fact because wall convectors are not everyday consumption goods, unlike men jackets or shirts. For the rest, the General Court confirmed that the submission of only 5 catalogues is insufficient to establish that many competitors use very similar designs for radiators. As a consequence, it is not established that the public will pay more attention to details such as the spacing between the tubes and the ratio between the height and depth of these tubes. The Board of Appeal was therefore correct to find that the contested design lacks, in this case, individual character. The third case selected is a case that deals with individual character of the design. And this case is similar to the famous, if you know it, case called Trunky, dealt with by the UK Supreme Court in March of last year. The UK Supreme Court endorsed the Court of Appeal's decision to dismiss an infringement action. The Board of Appeal considered that the designs produced a different overall impression on the informed user and that they are not in conflict within the meaning of Article 25 of the Community Regulation. The two protrusions in the contested design resemble horns with tips pointing downwards, as you can see. Whereas in the prior design, the two protrusions look simpler and straighter. The contested design presents 2 lines in relief on each larger side, and one of the lines appears to include a green line. In the prior design, there are no lines in relief. The use of colors in the registered community design and the absence of colors in the prior design is, in this case, of less importance. However, even though the prior design is in black and white, it can be seen that it is not split into different colors. The wheels of the prior design are also clearly not predominant in light color. So, for individual character, I think that the case speaks for itself. But, of course, in terms of interpretation of the law, we can always find different opinions on the same matters. I also mentioned at the beginning, and after having showed you a couple of examples, of 5 examples of case law of 2016 by the European courts and by the Boards of Appeal, I think it is also important and taking into consideration also the recent reform of our trademark law regulation that was concluded under the Latvian presidency in 2016, entering into force in 2016. I think that it is worthwhile to look at the question if there is a need or not to adapt the community design regulation to the world as we know it in 2017, since, of course, the regulation was created in 2002 and entered into force in 2003, and the world and technology evolved and changed quite a lot since then. For that purpose, the European Commission recently commissioned 2 studies in the design area, an economic study and a legal study. I will try to summarize the main findings of the legal study in this case, and just do a disclaimer that this study was not carried out by the European Commission, nor reflects the position of the European Commission, nor it reflects the position of the EUIPO. I will try to stay with the facts and the findings of the study that was in fact carried out by a private company called Time.Lex together with the Queen Mary University of London. The main purpose of the study is to analyze whether the existing legal framework contributes to the Innovation Union strategy, which aims to create an innovation-friendly environment, making it easier to turn ideas into products and bring growth to the EU economy and jobs. It examines the compatibility and interactions between national design protection systems, as harmonized by the directive, and the unitary protection afforded by the community design. It analyzes whether there are divergences in terminology, requirements and conditions for protections, or other aspects that pose problems to users, users of the system. It evaluates whether the EU system for designs protection, after almost 15 years of operation, is still working optimally or not. To do all of this, it analyzes four main questions. First, has harmonization facilitated design protection in the EU, and whether further harmonization is needed? Do we need further harmonization in terms of design protection in the EU? Secondly, evaluate the current two-tier system, national protection and community protection, contribution to the Innovation Union. Thirdly, does the current legal framework needs updating in light of technological advances? Fourth, is there a need for further harmonization of national legislation, in particular in relation to spare parts in complex products? One of the cases that I mentioned dealt with spare parts, and the effect of 3D printing on intellectual property. Those are the main questions that were proposed in the study. The main conclusions of the study are the following. The need to appreciate the power of convergence and the harmonizing impact of the EUIPO practice and decisions in the early years of a young species of law that is the EU design regime. The report concludes that in respect of several aspects of the design system, the desired level of harmonization has been achieved. So this is the first conclusion. The report also states in several areas that there is no need for revisions. Rather than EU law needs to be allowed to develop via judicial interpretation. So we need more case law coming out of our boards of appeal, our European courts, in order to develop the system. Thirdly, however, it identifies those areas of difficulty which have potential to negatively influentiate the accessibility and smooth running of the system. At the heart of the conflicting evidence and difficulties experienced by these very important stakeholders, national offices and the courts and consumers, is the very core of the law, namely the subject matter of protection. This continues to be the central point in terms of discussion on design law, the subject matter of protection. The report detects various trends of dissatisfaction, including the definition of design. What is a design? The concept of functionality, one of the other cases that I have mentioned in the beginning, the notion of disclosure, the scope of protection. In light of this, revisions to the design directive have been recommended, where changes to language or clarity in approaches are required. The report contains a secondary set of conclusions on the future of design law, specifically in two areas: spare parts, as I mentioned, and 3D printing. Regarding spare parts, the report presents a number of different options, without, in any case, proposing a specific one. In relation to 3D printing, the report concludes that, as this is a new area of technology, conclusions should not be drawn without further economic, academic, and judicial substantiation. So basically the report states that we are still not ready with the information that we have to take a decision on what to adapt or change in terms of design law due to 3D printing. In its recommendations, the report finds that there are economic reasons for retaining the national registration regime, but encourages further cooperation in areas that have caused divergences. In particular, the report highlights the need for a comprehensive fee review, but until that time, sees no scope for reducing the EUIPO fee for a single design. At the EUIPO, although we have a discount when you want to apply for a trademark using our web services of 15%, in what regards design that is administered by the same office, the regulation does not allow for this discount. And this is, of course, an incoherence in terms of the system that I think is difficult to justify. Instead, increased cooperation with national offices by way of software support and legal assistance should take priority over fee reductions. The report calls for clarity to be introduced into the definitions of a design, so what is a design, and considers the possibility of a narrow interpretation following the current case law of the General Court, which limits design rights to the visible part of products, or a broader interpretation extending the meaning of appearance to tactile aspects. The report recommends, therefore, that clarity be introduced into the recitals with a specific reference to the ancillary purpose of a design law is to protect the economic and or market value of a design, and to change the definition of a design to incorporate all relevant elements that contribute to the visual appearance and economic and or market value of the design, whilst clarifying that only those which are shown visibly, the ones that you can see, can be protected. What the study, in my opinion, does not explain is how tactically can be shown graphically and whether, taken into account the economic value of the design, which by nature is not visible, or at least for me it's not evident, would lead to a special status for a successful design, like for trademarks, when we talk about trademarks with reputation. Although the report concludes that the concepts of informed user, individual character, and different overall impression are largely satisfactory, thanks to the harmonization programs of the Office with the National Office and recent jurisprudence, has emphasized that the links between overall impression, design corpus, product nature, and industry sector in the reciters have created confusion among the users during these years. Product nature, thus, when assessing a design, individual character, the determination of the relevant prior art should take into account the nature of the product, the manner of the use of the product, the purpose for which that product is intended for, and the industrial sector to which it belongs or circulates within. This recommendation is in line with the group Nivelle's judgment, also a famous judgment in the area of designs, which the EUIPO has appealed. The proposal also introduced an element which is close to trademark law's principle of speciality, which runs against Article 36 of the Community Design Regulation. The designation of the product does not affect the scope of protection as such. The report recommends revisiting the provisions of Article 3, number 3 and 4 of the Design Directive and aligning them with the visibility doctrine established by the General Court in the Biscuit-Spolt case by establishing, first, that all designs, whether or not consisting of parts of complex products, must be visible in order to be protected. Secondly, the visibility criteria should be linked to the informed user perspective. Thirdly, to include protection for all features constituting the visual appearance of the design, including features of texture or materials which contribute to its economic and or market value. And fourth, to remove reference to normal usage or normal use, as this causes confusion, or clarify that this criteria is not applicable to all designs. Article 4, number 2 of the Design Regulation restricts the application of the visibility requirement to component parts of complex products, spare parts. As regards the notion of component parts of complex products, the report recognizes its complexity and the confusion that it causes, and thus suggests different options, one being removing the concept of component part in complex products from the regulation and from the directive, something that the European Commission already tried back in 2009 without success, since this is, of course, a controversial provision that divides member states in quite an evident manner. However, the report acknowledges that the issue is politically sensitive and particularly important for spare parts. Thus, it recommends that the notion be retained, but limited only to complex machinery. So this is one of the novelties of the report. So it should be retained, the provision, but it should be limited to complex machinery. On the issue of functionality, also addressed in one of the cases that I've selected early on, the report proposes either the irrelevance of the multiplicity of shapes approach in the Philips Electronic versus Remington case, which is current EUIPO practice. Second, to retain the current wording and allow the Court of Justice to determine the final approach to take. Its final conclusion on the issue is that clear legislative guidelines be incorporated into the directive and the regulation, stating that in determining whether features of appearance of a product are solely dictated by its technical function, due consideration should be given to whether the designer has some freedom in the development of features of appearance of the design, whether presence of difference between the existing design corpus and the contested design would demonstrate that the designer had some freedom. This conclusion would lead to the acceptance of the multiplicity of shapes theory. In relation to the overlap with copyright law, which is also an important element when we talk about design law, the report recommends that all member states should remove any legal hurdle to the cumulative protection of applied art by copyright, as emphasized already by the Court of Justice in the Floss ruling case 168/19. On the topic of graphic representation, also addressed in one of the previous cases, the report makes a number of recommendations for further convergence, particularly in the field of dotted lines, the use of dotted lines, which have already been agreed by the national offices in the framework of our convergence programs, and encourage further convergence of practices, in particular to judicial practices. The report further recommends that a higher number or even unlimited views be allowed and that the 3D representation be optional, but not mandatory. On the topic of dotted lines, the agreement reached by the EUIPO and its member states, national offices, in the framework of CP6 have now been reflected in the office guidelines and in the guidelines of our member states' national offices as from May 2016. So that recommendation, I would consider it to be closed through convergence between the EUIPO and the national offices. And these include an explanation that dotted lines are a way of disclaiming certain features of a design, which I think is also commonly agreed by the community, the design community at large. In relation to unlimited views, the office already allowed for 3D representation, which in essence allows for a design to be viewed from an unlimited number of angles, although the number of views permitted for the purpose of publication and registration is limited to 7 views. Moving on to further recommendations for the directive and for national offices, the report recommends that national offices make efforts to introduce a quick and inexpensive invalidation procedure and considers that the obligation to mirror Article 45 of the Trademark Directive would be beneficial. The report observes a lack of harmonization in respect of the period of deferment of the publication. Some member states do not have such a provision, and those that do, the period of deferral varies significantly, from 6 months to 30 months. So you see that there is no convergence in this respect too. But also that the term of protection for spare parts should also be touched upon. Some member states do not provide for such protection, and others do, but for different periods, from 15 to 25 years. Others protect spare parts under copyright law, such as France, which creates an inconsistent regime for the protection throughout the EU. The protection of spare parts and the copyright law also illustrates that the removal of any protection by design law would not fully solve the issue of the full liberalization of the secondary market for spare parts. So the liberalization of the market in what regards spare parts in the design directive would not be enough to in fact harmonize the design system among all the member states. In the framework of the further aims of the study, to evaluate whether the current legal infrastructure will withstand the test of time, the report analyzes 3D printing and concludes primarily that a comprehensive review of the impacts of 3D printing should be undertaken. However, it makes the tentative recommendation that the private and non-commercial use limitation be restricted to acts done for private and non-commercial purposes. Should these be allowed, provided they do not unduly prejudice the normal exploitation of the design. That intermediaries should be liable for authorizing design infringement, and that the definition of infringement be expanded to include creating a design document which is a record of a design without authorization, for instance. In conclusion to this option, the report recommends recasting Article 110 of the Design Regulation as a defense to infringement and moving it to Article 20 to clarify its effect and also its permanent status, that you cannot, of course, obtain through Article 110. It should also be amended to adopt the language within Recital 13. Remember one of the cases, Recital 13 and Article 110, so that the repair defense is limited to the must-match spare parts, namely parts whose appearance is dependent on the appearance of the complex product. Although the study advances some recommendations in a number of areas, it does not make groundbreaking recommendations. Most often, a set of alternative suggestions is presented without a clear prioritization, in my view, when the legal study does not merely propose to wait for further guidance of the Court of Justice and the Boards of Appeal of the Office. The legal study does not address also the extent to which there should be a further alignment, including in respect of procedural aspects of design registration between the directive and the design regulation, and also between the design regulation and the trademark regulation. Neither does it include an assessment of the EU fee system that remains unchanged since its creation in 2003. To conclude, a couple of questions from my side in this case that I would like to leave for your reflection. And since it is clear that the community design system shares with the community trademark system a great number of provisions, in particularly those dealing with procedural rules in inter partes proceedings, and that examiners dealing with both cancellation cases in trademarks and in design matters are the same and would improve consistency and a better alignment of these procedures aspects, be beneficial to both legal practitioners, you in this case, and our own EUIPO examiners. Thank you very much for your attention, and I will, of course, available to try to answer to any question that you might have. Thank you.